Good afternoon, everyone. On behalf of Legal Aid Alberta, thank you for joining us on the final day of Alberta Access to Justice Week for our webinar, Children in the Law, Representing Kids in High Conflict Cases. My name is Wyatt Fraser. I'm Legal Aid Alberta's Engagement Advisor, and I'll be helping make sure things run smoothly today. As we get started, I did want to speak to a few bits of housekeeping. We have a large audience joining us, so by default, your microphones and cameras are disabled so that we can better focus on our presenters. We have a lot to cover, so we'll be saving questions until the end. And to engage with us and ask a question, you can use the Q&A feature in Teams, which is available as a button in the top menu of your Teams window. You can click that. It'll give you a prompt to enter a question, which you can then submit. Please note that the information shared today is not legal advice and will not be able to answer questions seeking advice on individual cases. We are recording today's webinar, and the recording will be available later next week on our website under the events page. A copy of today's PowerPoint will be provided to all attendees via email later this afternoon. Near the end of today's session, we'll provide a link for you to fill out a quick survey to share your anonymous feedback about today's webinar. Your responses are key in helping us refine our public webinars and plan for future topics. In the spirit of reconciliation with Indigenous, First Nations, Métis, and Inuit peoples in Canada, Legal Aid Alberta makes a solemn pledge towards positive change in the legal system for fair representation with consideration of their unique and historical situations. We respectfully acknowledge that we are situated on the ancestral and traditional territory and travel routes of many peoples, including those on the lands of Treaties 4, 6, 7, 8, and 10, the Blackfoot Confederacy, Kainai, Piikani, Siksika, Dene, Saulteaux, Nakota Sioux, Stoney Nakoda, Cree, Tsuut'ina Nation, and the Métis people of Alberta. In an act of reconciliation and gratitude, we acknowledge all Indigenous, First Nations, Métis, and Inuit peoples who have lived in and cared for these lands for generations. We express our continued thanks to be able to work on these lands and represent Albertans in this territory. And now I'd like to introduce our three speakers for today. Andrea Doyle, Legal Aid Alberta's Senior Advisory Counsel, Family and Immigration, and staff lawyers Colleen Christie and Kevin Livingstone. Each of them has years of experience in representing children and is here today to share their knowledge and expertise on this important topic.
Excellent. Well, thank you very much, Wyatt. Today we have an hour to spend with you, but we have a pretty broad agenda of some issues that we're going to talk about. So what you're going to hear from us today is why should we hear from kids? Why should we involve them? What are the ways that you can actually bring a child's voice into proceedings? How do you go about getting a lawyer if we're going to get a lawyer in a high conflict parenting situation? And then what role will that lawyer take? How will they do their job? What will they put before the court? With a child, there's always issues about how do you determine if a child has capacity to provide instructions to a lawyer, because that really impacts what role we'll take. We're also going to talk about how do you meet with kids? They're not like adults. It's a little bit different in how you work with them. And who are some of the collaterals, the professionals that we might talk to? And then we're going to end with telling you talk about some misconceptions that people often have when it comes to representing children and children being involved in court proceedings. We're going to talk about some do's and some don'ts. So with that being said, I'm just going to start off by letting you know, today we're going to really focus on representation of children in the high conflict parenting matters, but Legal Aid Alberta provides counsel for children in other areas of law. In child welfare matters, representation of children is provided by the Office of the Children's Lawyer through their LRCY program. But Legal Aid Alberta also provides representation for children and youth who are involved in the criminal justice system. We also have children sometimes who are also involved in immigration-related matters where their parents may be bringing a refugee claim and the kids may be involved in it. So we provide counsel to assist those families. And another area where Legal Aid Alberta provides representation for children and youth is under the Protection of Children Abusing Drugs Act, PCHAD. So we provide legal assistance for children with those matters as well. So the query becomes, why should we care about children being involved in parenting matters in particular? It's really important to bring children into parenting matters because they have rights and their rights need to be protected. So rather than asking the question, why should we care? then why shouldn't we listen? Should be the better question that we should be thinking about. Children want to be heard. They want to know about what's happening in their lives after their parents separate. There's significant research out there that the majority of children want to participate and be listened to. Generally, we achieve much better outcomes for children with parenting situations when kids feel like they've been heard and their views and preferences have at least been listened to. And we find that children are much more likely to adhere to and be happy with parenting relationships and actually continue to follow court orders that are required for their parenting situations if they feel like they've been heard and their views respected, even if they're not exactly at the end of the day what they want it to happen. But when they feel heard, they are much more likely to comply. Parents as well also tend to focus less on their battle, more on their kids when there is the child's voice before the court and being shared with the parents. They'll focus on what is their children's needs much better than if there's not counsel involved. And hearing from children really does allow parents to know what their child's views and preferences are and what steps they need to take that into consideration and often improve the relationship. And we're going to talk a lot at the end about ways to improve that relationship, things to do, things not to do, and what are some of those impacts of the toxic stress that kids can be exposed to when parents separate. There's absolutely no evidence out there that when children have an opportunity to speak to a lawyer or to a judge that it's harmful to them. What the evidence better shows is that it's the harm when parents are fighting in front of their children or over their children. That's what causes the toxic stress to kids. And again, we're going to talk a lot more about that a little bit down the road. Children are entitled to meaningful participation in decisions that affect them. And from a legal perspective, we have obligations both under the legislation we're going to talk about in a few minutes, the Divorce Act, the Family Law Act, and the United Nations Conventions on the Right of the Child. When we say kids get an opportunity to provide some input, it does not mean that we want to put children in a situation where they need to feel like they have to take sides or choose between their parents. It means that children should have a voice, but not a choice. And you're going to hear a lot more about that in a few minutes. Now, when it comes to parenting decisions, courts, when making decisions, the primary consideration for them is what is in the child's best interest. We hear lots about what's in the child's best interest. And there are many things that a court will take into consideration when making that decision. And specifically, one of those things that a court will take into consideration is the views and preferences of a child. Specifically, the legislation, the Divorce Act, which governs parties who are married who are separating, there's a very specific provision under 16 subsection E that the court shall consider the child's views and preferences, giving due weight to the child's age and maturity, unless they cannot be reasonably ascertained. And we're going to talk a little bit more about age and maturity and how do you assess that. Under the Family Law Act, which is the provincial legislation, it specifically says under section 18, subsection 2, subsection B, subsection 4, that the court shall consider all the children's needs and circumstances, including the child's views and preferences, to the extent that it's appropriate to do so. Now, there are a number of ways that a child's voice can become involved in family law proceedings. There's not one size fits all. It can be a number of different ways, and we'll talk a little bit about those. One is really informally. It can be from parents telling a court or sharing what a child has told them, what their views and preferences are. Sometimes you'll see parents who will include that information in an affidavit or they testify at trial to say, this is what my child has told me. Now, there's always some concerns with respect to that because, again, parents are involved in litigation. And obviously, if they're at the situation when they're at a trial and they're trying to tell the court what a child has had to say, there may be concerns about how honest that information is, and whether or not it's an accurate statement, and whether or not there may be some influence with respect to that. Another way that you can get the child's voice before the court is through direct evidence from the child. Sometimes that could be through a video or a letter or an affidavit. Rarely will a child testify in court. When it comes to putting a video or a letter before court, courts will often be very concerned about that because they don't know what were the circumstances surrounding the creation of that video, what were the circumstances regarding the child writing that letter. So there's real concerns with respect to that, of potentially that there's some influence or coaching happening with respect to it. Rarely do children actually testify in a trial or in court. And quite often, we all want to ensure that they don't have to do that. Because if they do that, then they have to be cross-examined by people, and nobody wants to put a child in that situation. And you also have to think about what are the long-term consequences of having a child having to testify, usually about a parent or against a parent. You don't just think about the short-term gain, you have to think about the long-term consequences. Quite often, one of the other ways that we'll get a child's voice before a court is through a third party, such as a counselor that the child has worked with, a teacher that the child has worked with, or some other third-party professionals who can share what that child has specifically said to them. The more formal routes are through what is called a voice of the child report. And those can be an evaluative or a non-evaluative, where you have an evaluative one is where you have a psychologist or a mental health professional who assesses the child, talks to them, gets their views and preferences, may do some testing with respect to the child, and then evaluates that voice of the child and puts it before the court. You can also have another type, which is called a non-evaluative voice of the child report. And sometimes those are where a lawyer meets with a child or somebody meets with a child and writes down verbatim what a child has had to say. They're not going to evaluate the child's comments. They're just going to put that evidence before the court. You can also have sometimes a forensic evaluation, and those are things called like parenting bilateral custody assessments or parenting evaluations that look not only at what the child has to say, but the whole family situation and give a sense of what's going on with this family. These are done by parenting experts. They are incredibly costly. Generally, we're looking at a cost of somewhere between $20,000 to $40,000. They take a great deal of time. Another route that you will sometimes see is a child being included in a mediation type thing where they actually come in and share their thoughts and then sort of leave. Sometimes you'll have judicial interviews where a judge will actually meet with a child under certain circumstances, sometimes in their office, sometimes in the courtroom, and actually meet with a child and hear what that child's views and preferences are. That is one that some judges are comfortable doing, others don't. There's no set protocols at this point in time as to what that would look like. But the route that we're going to talk about mostly today is hearing the voice of a child through a lawyer being appointed for a child. And representation of children in high conflict matters is why we're here today. Each of the methods that we're talking about have their pros and have their cons. And it doesn't necessarily mean that they're going to be the only methods that you use. Sometimes they're done in combination. Sometimes you'll have a lawyer appointed for a child, but you will also have a voice of the child report being done by psychologists. That's just an example. Now, turning to the law, as lawyers always do, just because we know we have some lawyers in the audience, but we also have a lot of people from the public. So in Alberta, there are generally two courts that hear family law matters. There's the Court of Appeal that hears appeals matters, but generally most parenting matters are done before the Court of King's Bench or the Alberta Court of Justice. The Court of King's Bench is a superior court. The Alberta Court of Justice is a statutory court, and that means it can only apply the law as set out in statute. There are specific provisions in various pieces of legislation in Alberta and federally that specifically refer to children having rights and the ability to appoint counsel for a child. In the Court of King's Bench, they can hear matters under the Family Law Act where there's a specific provision that allows for a lawyer to be appointed. And they can also under the Divorce Act. There's no specific provision, but the court, because it's a superior court, has some inherent in parents' patri jurisdiction that allows it to appoint counsel. As well, the Alberta Court of Justice, if matters are there, a parenting matter is under the Family Law Act, they can appoint counsel. There's a very specific provision. And in child welfare matters, although we're not talking specifically about those today, there's specific provisions in the Child, Youth, and Family Enhancement Act. Section 112 allows for counsel to be appointed for a child. In addition to our federal and provincial laws, Canada is also a signatory to what is known internationally as the United Nations Conventions on the Rights of a Child. Canada, our laws are primarily similar in many respects. So we don't have a specific provision that says you must comply with the convention, but our laws are pretty much conforming with the rights of the convention. So we see it as applying in Canada. So there are very specific provisions, and you'll hear lawyers talking about the Convention on the Rights of a Child. It codifies many of those rights for children. And so for our purposes today, we're going to specifically talk about the relevant sections, which are Article 3, that states that all actions concerning children, whether they're undertaken by the public, so meaning through the director, through child services matters, or private social matters, such as things like parenting between two parents, that the best interest of the child is the primary consideration. So very similar to our current legislation under the Family Law Act and the Divorce Act. And Article 12, which is really relevant, indicates that states shall assure to the child who's capable of forming his or her own views and the right to express those views freely in all matters affecting their views, and give them due weight in accordance with their age and maturity. And so for the purposes of that, children have the right to be heard, and they have the right to actually have information and an understanding of what's going on. Now, under the convention, participation is not just one and done. You see them once and that's it. Participation is a process. It's not a momentary thing. It can be involved a number of meetings with children, a number of ways of meeting with children a number of times, and children have the right not to participate if they don't want to. But under the convention, participation includes providing the child information, making them aware of the evidence and the applicable legal standards, as well as canvassing the child's perspectives in all decisions that are being made with respect to them, reviewing decisions, explaining to them the court process, as well as explaining to them some delays in the court process. Children have very specific rights under the convention. Now I'm going to turn it over to Kevin, who's going to talk about a few cautions.
Yes, thank you. So just some general cautions when we're getting information from children and getting their views and preferences. And that's that sometimes the information may not be reliable. The child may say, Mom said this, Dad did that. We don't cross-examine them to find out, well, isn't it true that this actually happened? That's not our purpose. We don't cross-examine. We just take the facts as they express it to us. Another example of that is children perceive time a lot differently than adults do. If the child says this happened a really, really long time ago, that might mean a month ago. And so we just have to be cautious when we're reflecting on what the children have told us. And their views and preferences that they're telling us, that might not reflect their true feelings. And part of this is it takes a lot of time to build trust and rapport with the child. And that's one of the reasons why we usually do several interviews with the children. Children also may feel like they're caught in the middle and tell each parent what they want to hear. And it isn't the case that they're lying in that situation. Quite often it's when the child's with mom, child wants to be with mom. When child's with dad, child wants to be with dad. And so they are caught in the middle. And so if a child, for example, says, Mom, I really don't want to go back to dad's, that doesn't mean that anything bad is happening at dad's necessarily. It might mean that right now kid's really enjoying the time at mom's and doesn't want to do the transition. Kids can also be manipulated. That we'll get into discussing alienation and estrangement a little bit more later. And kids can be traumatized by their involvement and by things that are happening. So if something traumatic does happen to them, what we don't want to do is keep asking them over and over again to tell their story, what happened, because that just keeps re-traumatizing them. And there's certainly some case law and evidence that you don't want to keep doing that. Kids also don't understand the court process, which is not surprising since it's difficult for adults to navigate quite often. And so it's getting them the appropriate information about the court process so that they can understand it at their level. And finally, a big caution, don't expose them to toxic stress. As an example, and this is what I heard a psychologist say at one seminar, if you tell your child that the other parent is worthless or whatever negative adjective you want to use, and the other parent is saying the same thing, the message the child hears is, I'm half from mom and half from dad, so I'm 100% worthless. We, of course, don't want that. So switching gears a little bit, representing children. In high conflict parenting matters, there's two ways. Number one, by privately retained counsel. We don't see that very often. I don't, of course, because I work for Legal Aid. I haven't seen it that often in the court system as well. In that case, both parents would have to agree. The lawyer for the children would be neutral in that case. In child welfare matters, the appointment of counsel for the children goes through the Office of the Child and Youth Advocate. It's through a different program, not through Legal Aid. What we're going to be talking about the rest of the day and what we've talked about so far is representing children in high conflict parenting matters through Legal Aid, which is by way of a court order. All right. Colleen, it's up to you.
Thank you. So some factors to consider when the court orders counsel is that to keep in mind that the court is very careful about making orders appointing counsel for the children. They don't do it just because one or both parents are requesting it. There are numerous factors that the court has to consider, and they look at whether there is a mature child with their views and preferences, whether or not there are allegations of abuse, whether or not there are allegations of alienation and estrangement, if there is ongoing high conflict, intractable litigation, if the child has medical, educational, or psychological issues, and whether or not there are any challenges with evidence or services. The leading case is Puchak and Puchak, and that identifies specific factors to consider whether or not counsel should be appointed. Just because you meet one of the factors in Puchak, it doesn't necessarily mean that that is enough to have counsel appointed. The law is continuing to evolve in this area, and the court is trying to balance the need and purpose of hearing from the child against the risk of possible harm of involving the child. So the court also wants to ensure that the child is capable of forming their own views. And a lot of justices seem to equate this with a quote unquote proper age and degree of maturity. There's a decision by Justice Feth, DCE and DE, and I think we'll provide these citations at the end, that deals with a new framework for considering appointment in cases. And in that particular case, the court wanted to look at, what were the issues that were affecting the children, assessing the interests of the children and how those would be affected, the age and maturity of the child, and their ability to provide their views, the possible role that was proposed for counsel, the information being sought, whether counsel was necessary or desirable, or whether the information could be relayed in any other way. And then in terms of how to get counsel, that's the next one, yeah. Once ordered, either the parties agree to the lawyer's appointment by consent, or the court may on its own initiative order counsel. Then the order should direct the parties to contact Legal Aid Alberta. So one of the parents would contact our contact center, go through the application. There are absolutely no eligibility requirements on this application. However, a copy of the order is required. The Legal Aid Alberta lawyers appointed, they do charge a reduced hourly rate of $125 per hour, plus any miscellaneous expenses. The Legal Aid Alberta, the lawyer is paid directly by Legal Aid Alberta, and the parties repay Legal Aid Alberta with no interest. And the balance is typically split equally unless the court order specifies otherwise. The alternative, of course, is that the parties may agree to retain private counsel and pay that lawyer's billable rate. And then the considerations for Legal Aid Alberta, the matters have to be deemed by the court to be high conflict, and there has to be a court order. It is a priority area for the Legal Aid Alberta staff offices and Legal Aid Alberta's child representation panel of roster lawyers. These are lawyers that have their own practice, but they accept files from Legal Aid Alberta. Clients cannot just choose any lawyer they want, nor can the court expect that Legal Aid Alberta will just respect that request. The appointments only go out to roster if there's a conflict, or if the staff offices are at capacity, or if there's no staff office that serves a specific geographic location, for example, Peace River. Or if the child has a pre-existing relationship with a lawyer, for example, that counsel had already represented them previously, or it's an LRCY lawyer, then Legal Aid will try to honor that pre-existing relationship as much as possible. I'm going to turn it back to Andrea now.
Okay, so just so everybody knows, not every lawyer who wants to be counsel for a child is able to do so. We have very specific standards for the lawyers that do the child representation work. And so we've always had a team of lawyers at Legal Aid Alberta that does that work, as well as we have lawyers who are in private practice who do it. So in 2022, we actually created what is called the Legal Aid Alberta Child Representation Panel. So lawyers who are on the roster who want to do this work had to go through an application process, and they were in panel for a period of 3 years. We're just kind of at the point where we're about to re-impanel with respect to that. But lawyers who do this work must have a minimum of 5 years practicing family law, not 5 years at the bar, but 5 years of actually practicing family law. So if they're dabbling in about 10 different things, that wouldn't do it. They have to attend training and have experience in representing children, have those skills to be able to meet with children, assess children's ability to share information, get them to open up. They have to have that experience, and they have to be willing to follow best practices in the area with respect to representation of children. They also have to have a really good understanding of the ages and stages of development of children, and have an understanding of the brain science and the impact of toxic stress, the impact of families disputing over them. And there's also a requirement that there's a commitment to continuing legal education. So each and every lawyer on the panel, as well as the staff lawyers, who do this work, all have to do a minimum of 8 hours per year in continuing legal education in the area of child representation. So that's a bit about our panel. Now over to Kevin.
Yes. So a lawyer can take different roles once appointed to represent a child. And these are direct advocate, interest entitlements, amicus curiae, or guardian ad litem. Speaking about the direct advocate role, this is the traditional advocate role, such as if a lawyer is representing mom or dad. It's the same kind of role if a lawyer is representing a child, which means that there is the lawyer meets with the child, gives legal advice, and then advocates for that child's views and preferences, whether or not those views and preferences are in the best interests of the child, as perceived by the lawyer. There is also a solicitor-client privilege, which means that if the child tells the lawyer something, that is confidential unless the child says that that information can be released, just as with an adult client. There are the exceptions, of course, and that would be if the child is being harmed by somebody, or is going to harm somebody, or is going to harm themselves. And then those things are, of course, reportable, with the key being keep the child safe. In the direct advocate role, the court, of course, can accept or reject the child's position. And that's like everybody going to court. It's the judge that makes a decision. In the interests and entitlement role, this is it's a developing role, fairly new, came into being under from LRCY, the body that appoints children to represent, or lawyers to represent children in the child welfare matters. And if a child is able to instruct counsel, then counsel takes those instructions directly from the child and is in a direct advocate role. But sometimes a child does not have that ability. And then the appointed lawyer must fully examine the child's interests and entitlements, and then present evidence and act in accordance with a position that honors the most favorable outcome for the child. The solicitor-client privilege still applies subject to harm exceptions. And Justice Leparco, in her SK versus DG decision in 2022, says this: interest and entitlement advocacy is where a child cannot articulate a wish, preference, or viewpoint, and thus the role of counsel shall be to objectively explore all the interests and entitlements of the child, including but not limited to physical security and safety, emotional well-being, education, health, religion, family connections, and social involvement. End quote. So this is a role that is, as I said, increasing in importance in the court system. Another role that a lawyer can take is called amicus curiae, which is Latin for friend of the court. And in this case, the lawyer does not represent the child and is not bound by solicitor-client privilege. And instead, it is the court. The court has to appoint this role to a lawyer, and that will happen if there's situations where there's serious concern about undue influence, coaching, alienation, and that kind of thing. And that's where the children's views and preferences are so bound up in what the parents saying that the children's views and preferences are not actually independent. So the lawyer in this case maintains neutrality, still will advise the court of the child's views and preferences and wishes, and will otherwise assist the court in making the decision. And some of the ways that the lawyer can assist the court is by gathering information, retaining professionals as needed, and then advancing all relevant evidence before the court, such as during cross-examination. The current form of order that the Court of King's Bench is using, and actually Court of Justice as well, says if there is a reason that causes counsel to be concerned about the sincerity of the child client's instructions, such as the belief the child is subjected to coaching, duress, resist or refuse dynamics, and or parental alienation, they shall advise the court so that it may determine whether to relieve counsel of their duties and appoint an amicus curiae. And Justice Leparco in the SK decision previously mentioned says that only the court can appoint an amicus curiae. The last role that a lawyer can take is guardian ad litem, or this is where the lawyer becomes a guardian for the purpose of the litigation only, not the guardian in any other sense. It's just that the lawyer is deciding what's in the child's best interests and making submissions based on what the lawyer perceives to be the child's best interests, and can even act contrary to what the child's views and preferences are. And this role is kind of being phased out. You still see it in some court orders, but it's less common now. The next slide talks about how do we determine what role. Now, given that there are these different roles that a lawyer can take, it's how do we determine? And there have been several recent significant decisions about this recently. The SK decision previously mentioned, Justice Feth's decision DCE and DE 2021 ABQB 909, and then Justice Marion's decision JC and KC 2022 ABKB 707, which are must-read cases for lawyers representing children. And they will be provided, I believe, at the end, the references. In order to determine what role a lawyer should take, the first thing, the obvious thing to do is to read the appointing order, because quite often it may specify a role. And the lawyer should be aware of the new form of order that is being circulated, or the most recent form of order. And check that, and if it specifies a role, then you know what to do. Sometimes the order says you need to meet with the child first and determine if the child has capacity. And so after you do that, have the meeting, decide capacity issues, and read the pleadings to get a background of what's going on. Then you have a better idea of where to go. I think that's enough on that.
Thanks, Kevin. So I'm going to talk about how we assess a child's capacity. Pursuant to our code of conduct, our code of professional conduct, we're going to look at how to assess capacity. So Rule 3.2 through 3.15 advises that the key to legal capacity is whether the client has the ability to understand the information relative to the decision that has to be made, and whether the client is able to appreciate the reasonably foreseeable consequences of their decision or lack of decision. So in simple terms, what we're looking for is whether the child is capable of making reasonable choices and whether they can exercise judgment without any undue adult influence. While age can factor in, capacity is contextual and based on the child's appreciation of the circumstances. Both objective and subjective considerations ensure that the child appreciates the foreseeable consequences that flow from their expression. Now, the standards should not be set high, only a basic understanding of the issues involved and the ability to articulate a wish, preference, or position about their outcome is needed. There should be a presumption of capacity, and where the child is expressing clear and consistent preferences, these should be a presumption of instructional advocacy. Now, there are some instances where the child has capacity, but they're unwilling to instruct or participate in the proceeding. And then some counsel will have to decide whether they cannot be a direct advocate, even though the child does have capacity. As mentioned previously, the child has to be willing to participate. There are a few signs of limited capacity, and that can include the child frequently changes their mind, the instructions that you're receiving are confusing or inconsistent, or there is an actual risk of harm in the desired plan articulated by the child. And then in order to test capacity, and there's ways that Children's Counsel can look to test a child's capacity. So what we want to look for is whether they have an appreciation and understanding of the consequences of their preferences. Are there sound logical reasoning for those preferences? And there are instances in which Children's Counsel may wish to obtain an opinion from other collateral, such as a counselor. And there are many factors that can affect capacity, including age, alignment with one of the parents, manipulation, disability, or emotional development.
Now I'm going to talk a little bit about meeting with children. So kids are not like your normal adult client. You have to build a rapport with them. They're coming in to talk to a stranger. They don't know who you are from a hole in the head. So you actually have to build Give some time for them to get used to you, build that rapport, and allow them an opportunity to open up and to actually trust you. So it's not just going to be if your child is going to have counsel appointed, it's not just going to be a one appointment and one and done and they're never going to see them again. It often takes a number of appointments for lawyers to build that trust. How do you get kids to open up? They're not like adults. You don't cross-examine them. You don't direct the conversation. You really want them to have an opportunity to tell you their story. So sometimes we don't, as child's counsel, people kind of think we do. We don't go in and say, hey, who do you want to live with? Do you like your mom? Do you like your dad? Not at all. You give a child an opportunity to open up. You ask them very open questions. You don't lead them as to this is what I want to hear. Sometimes we actually use all kinds of different methods to get kids to open up. Some of us have done training, we do activities, sometimes we color, sometimes we Lego, kids talk things, and sometimes we use things like bear cards, which are activities that help children to open up and talk about their family. They can talk about two worlds. As well as child's counsel, we also collect information not just from the child, but from other collateral. So professionals who are involved with children, such as teachers, such as doctors, such as counselors, to be able to make sure we get a really good picture of what's going on with this child. They are by far the most fun clients to work with, but it takes a while. And that's why it's really important that the lawyers that do this work have proper training and experience to be able to do so. I'll move it on again.
Okay, some misconceptions. The biggest one is the age. There is no set age where a child gets to make a decision other than when they turn 18, then they can decide. Sometimes parents have this misconception that as soon as a child turns 12, they can make the decision, or 14, or whatever other age. There is no set age. It's more of a sliding scale. The older the child is, the more likely a judge is to place more weight on the child's views and preferences. So just don't think that there is a set age, because there isn't. You may have heard the expression, a child has a voice but not a choice. So that goes along with the no set age. The children, their views and preferences are important, but they don't get to decide. It's the judge that makes a decision after weighing all of the evidence, which includes the child's views and preferences. And the court will decide how much weight to place on the child's views and preferences. It might be that the judge places very little weight, and there's other factors that are more important. It might be the most important factor, and it just depends on each case. Counsel for the children are not investigative reporters. We will not dig down deep and get different facts than what the child is telling us in most cases. As Andrea mentioned, we will talk to collateral sometimes, teachers and counselors and so forth. But if the child is telling us one version of events, we don't dig down and say, well, I saw this other version of events, tell me which one is true. We don't do that. Another misconception is that sometimes we are there to act as mediators between mom and dad. And that is not the case. We can help with settlement discussions, but our role is not to act as mediators. And it's a different dynamic if you have a mediator involved. Also, sometimes parents will email counsel for the children and laying out their argument about why something is best for the child. It's not our job to be the decision makers. Our job is just to get the views and preferences from the children. And so you don't need to convince the lawyer for the child of any particular fact or not. It's save that for the judge. What kids need in this process, and you can see the bullets there: stability, consistency, quality relationship, to be a kid, financial support. All of this comes into play by giving children age-appropriate information. you could share something with a teenager that you should not be sharing with a 6-year-old. The child should have age-appropriate input in decision-making and planning. It's don't make the children the decision makers either, but give them an opportunity to participate in what, for example, a schedule looks like. They need to know that this whole situation, this court battle, is not their fault. It's between the parents, and the kids should be kept clear of that as much as possible. They need to know that it's okay to love both parents, to have a relationship with each parent. As I said previously, if the message they're getting is that mom is all bad and dad is all bad, well, I'm half of each, so I'm all bad, that's not a good place to put kids. Yeah, that's a good place to switch. So back to Colleen.
Thanks, Kevin. So we just have some recommendations in terms of things not to do. So what we want to look for is that parents are not allowing the child to hear or see any conflict, that they are doing their best to ensure that the child is not exposed to any parental issues or toxic stress. Obviously, we're suggesting do not lean on your child for emotional support. As well, don't become too permissive. Please keep in mind that you shouldn't abandon your child's schedules or routines or lobby for favorites. Our recommendations also include, not being a gatekeeper or allowing the child to have too much responsibility or control over their situation. And on the flip side, in terms of positive parenting strategies that we could recommend, is obviously encouraging time with the other parent, speaking positively about the other parent, informing the other parent about the child and their activities, allowing flexibility for your child to participate in events, being supportive of the other parent's needs, giving your child two parents who are winners, problem solving without the child present, and making sure to take care of yourself, because you can't pour from an empty cup, obviously. Oh, Andrea, you're muted.
Sorry, we're going to end our session today with you may hear from lawyers when they argue things, but talking about toxic stress. When kids are hearing and being involved in the parent separation and the issues and the arguments, it causes a great deal of toxic stress. And toxic stress is something you don't want your child to be exposed to. As a baby, throughout children's development up to the age of 25, their brain is developing during that time, and toxic stress has a very negative impact on it. It can undermine their executive function, their ability to make reasoned decisions or impulse control. It deregulates their stress response, their flight responses, and causes numerous risks for issues down the road. Anybody who's going to be involved in the family system are going to have to want to go to court, are going to have to take the parenting after separation course. It's a condition precedent now. You have to do it if you want to be involved in the court system. As part of that, there's also going to be references to the Alberta Wellness Initiative and the Brain Story. I can't tell you enough how important it is for parents to watch those videos and see the impact of fighting on their kids. And there's a whole list of things that toxic stress from parental separation and that conflict that can cause kids. And there's no parent out there who wants to do this. And some of those include, and if I'm on your file, you'll hear me telling this to the judge all the time, that some of the exposure to parental conflict can cause things as poor academic achievement. Your children don't do as well at school. They can't concentrate. It can be behavioral problems that can develop for them, where they see parents who can't control their behavior. They sometimes do the same things and they have behavioral problems. We also see higher incidence of things such as addictions, mental health issues, suicide, risky sexualized behavior, They may be more apt to be involved in family violence and have relationship issues and have separation issues with their own relationships. They can have things such as homelessness, unstable employment, get involved in the criminal justice system, and there also could be health impacts as well. Things such as cardiovascular issues, immune issues, chronic pain, memory loss, and even early death. Every parent out there desperately loves their children. So think about that when it comes to making decisions for your kids and exposing kids to toxic stress. You don't want to do it, your children don't need it. So with that being said, we're all here to help the kids. Parents are here to help the kids, and we are happy to take any questions that you may have.
Perfect. Thanks, Andrea. And then just as a reminder for folks, you can ask questions using the Q&A button at the top of your Teams if you're on your computer, or if you're on your mobile phone, it should be near the bottom. There'll be a little button that says Q&A. It will give you a prompt to enter a question. One of the first questions we have here is, what can be done if there's no court order, but social services are involved?
To get counsel for a child appointed. So in order for a child to get counsel in a parenting matter, there actually has to be a parenting application before the court. So there has to be court proceedings. If it is a child welfare matter, if child services is involved and they've commenced a court application, then as we indicated earlier, there is a mechanism to get a lawyer appointed for a child, and that is through the Child, Youth and Family Enhancement Act, Section 112. You can ask a court to make an order for that, or as well, they allow appointments to be made when somebody contacts them and requests that a lawyer be appointed for the child. So LRCY does that work. So there are mechanisms for sure to get counsel appointed for a child when child services has commenced court proceedings.
Okay, thank you. We had a additional question. You have said that a judge must make a court order for a children's counsel be appointed. How can parents or counsel of parents ask the judge to consider this option for their child?
I can answer that. The parent would need to bring a court application. Unless both parents are agreeing, in which case it could be a consent order. If they're not agreeing though, then it's a court application, and you would do an affidavit and give your evidence to the judge. The other side would get a chance to respond. The judge would then make the decision.
So there is a little box in the Family Law Act forms that says other. That's where you tick that box and you put appointment of counsel, and that's where, but again, as we said earlier, there's got to be reasons for it. Judge is not going to appoint in every case. So think about some of the things. You'll get a copy of the PowerPoint today, so you'll hear some of those things, some of those reasons why a court might make a decision to appoint a lawyer for a child.
Okay. We had a question about what experiences have you had, if any, with techniques employing therapy animals like dogs in assisting children to engage in the legal process?
I can honestly say I've personally never used a pet to engage a child, but certainly there are mechanisms out there through therapy for that to happen. I certainly have known of clients of mine who've had to testify in criminal proceedings where certainly dogs have been used to help them sort of get through that therapy. But personally, I haven't had experience with it, but certainly it's available. There are various organizations that have pet therapy, and certainly I can tell you, I talk to my kids about my pets, and that's one of those things. When I'm building a rapport with kids, I'll talk to them about their pets. From kids' perspective, you want to hear what's really important to them, and often their parents are important to them, but their pets are really important to them too. So building that rapport, talking about, but certainly if a child were in a situation where they had to testify, that's more likely where an animal may come in to help them get through that experience.
Sandra, we had a question, someone or a comment. So I have a lawyer. When I go to court, can I request them to request the judge for a specific type of representation, such as amicus curiae, and the evidence on why I feel this is the best option, or will the judge themselves decide which of the roles is best?
I can take that one too, if you like. So sometimes, as Kevin indicated, a judge will already have made a decision as to what role they want you to take. the more current order, so generally judges, if kids have capacity, as Colleen talked about, they have the ability to understand the nature and consequences of their decisions, then we're kind of suggested that we do that direct advocacy. If they're young, they're not able to understand the consequences, or sometimes kids are so young that they're not verbal, then an interest in entitlement may be that role. In some cases, an amicus may be an appropriate role. And again, we're talking there, those are those cases where there may be undue influence and there may be concern as to whether or not a child's wishes are actually their true wishes or whether they're being influenced. In those cases, to have that amicus appointed, it has to go back before the court. There has to be some information as to why that would be the more appropriate role. Have I done amicus? Sure, I've done amicus in lots of files, but you have to have, the court has, because you have to be relieved of your loyalty to your client and those privileges. So a court has to make that decision. You can't just see a file and say, hey, I'm going to be an amicus on this one. You have to, you may think that, but you have to go back to the court and explain why. The lawyer has to go back to court and explain why it's more appropriate to be an amicus in that particular situation.
Yeah, and at the initial stage, the parents for the lawyers could make their pitch as to what role, but it's up to the judge.
Okay, thanks, guys. And just looking at time, I know we are getting a lot of questions in, so we apologize that we won't be able to get to all questions. We do thank everyone for submitting questions here. We've also put a link into the chat for a quick survey that you can fill out just to share feedback about today's session. We'll still keep going with a couple more questions here, but if you click on the chat button, you'll be able to see the link to the survey, and we will send that in the email, which we'll send later this afternoon, which will also have the PowerPoint presentation, as well as some of the cases that have been referenced in the materials here today. So we had a question, this one's directed towards Andrea. How do you separate the comments on the impact of toxic stress on children? For example, counsel giving evidence, the time, the process and docket versus trial, wouldn't that make a difference?
Sorry, say that latter part?
So I think they're kind of I think the heart is asking, how can you avoid causing toxic stress when involving a child for them giving evidence? So if a counsel is giving evidence, how do you keep the child separate from toxic stress?
Well, the toxic stress like kids usually have is when they're exposed to their parents fighting back and forth. And most of the evidence shows that you're not causing toxic stress to a child by having to talk to a lawyer or talk to a judge. And Nick Balla has done some work with respect to that. It's the exposure to that conflict. And certainly lawyers have an obligation to share information with kids and explain it, but you're doing it in age-appropriate language and at the level of a child. So what I'm going to share with a 5-year-old and what I'm going to share with a teenager may be very different in how I phrase that. So certainly our job is to try to keep kids away from as much of the toxic stress as possible. But the reality is we're not getting involved unless it's a high conflict. The court's made a decision that this is a high conflict matter, so kids are already exposed. So what we're suggesting is, as parents, do your best to keep them out of the middle. Don't be questioning them about, and don't be, as Colleen talked about, trying to be the favorite or not encouraging other relationships. Parents have a huge impact on their children. And if lawyers involved, then yes, we also have to make decisions about how many times we go see kids, because every time we talk to kids about things, it can be bringing back really negative memories that they have. So we have to do our best to act in a very trauma-informed way to ensure we're not causing more stress to a child. So it is a fine line. There's no question with respect to it. You've got to talk to them about various things, but you try to do it in an age-appropriate and a trauma-informed way.
Thanks, Andrea. And you see we're coming right up on our time. So again, our apologies for not being able to answer all the questions that are being asked in the Q&A feature. We did want to thank our 3 presenters, Andrea, Kevin, and Colleen, for taking the time today to share their knowledge and expertise. And we also want to say thank you to everyone who attended today. Thanks for taking your lunch hour on a Friday. We hope everyone has a fantastic afternoon and a great weekend. And then as a final reminder, we will send out a copy of the PowerPoint that was shared today. The recording of the session will be available on Legal Aid's website under the events page, probably closer to mid next week. We can send a follow-up email as well, letting people know once that's available. And when you have a chance, please fill out the quick survey that's posted in chat, and the link to that will also be included in the email that we send shortly.
Thank you so much for sharing your time with us today.